The following is a CUNY TV special presentation.
Good morning. I'm John Darnton, curator of the George Polk Awards, and I want to welcome you to the Sources and Secrets Conference. The idea for this conference came in an email many months ago from William Polk, who is the younger brother of George Polk, the CBS reporter who was murdered on assignment in Greece. William was concerned about the Espionage Act, and he wrote, "The issues that my brother's murder brought to the fore were, 1, can you silence a story by eliminating the reporter? And 2, can a free society operate if the sources of information on public affairs are closed or even severely constrained?" His concern, it turned out, was felt, in fact, by many in our profession. Over 50 organizations have sponsored and supported this conference, and we thank them for that. It may be that conflict between the government and the press is inevitable, but rarely has that conflict been as raw and as raging as it is now, post-9/11 and in the post-Snowden world. We hope today to shed some light and maybe even some needed heat on the underlying issue. And to start, it gives me pleasure to introduce a man who has been engaged in a long, lonely court battle to defend the confidentiality of a news source, Mr. James Risen of the New York Times. Thank you.
I thought I would just start by kind of providing a little bit of an overview of the general issues that all the different panels are going to be discussing today. And I think that I'd like to start with a discussion, as John was just discussing, about the relationship between the government and the press today. I think we're going to look back at this period and realize that since 9/11, we've had the real legacy of the war on terror of the Bush administration and of the Obama administration has been a severe erosion in civil liberties in America. And that a significant part of that is about freedom of the press in the United States. I think this is the worst time period in my career as a journalist in terms of press freedom. I think that the Obama administration has doubled down on the kind of reductions in press freedom that began under the Bush administration. And they are engaged in the kind of aggressive anti-press activities that the Bush administration only contemplated and never pursued. And I think it's the great irony of a liberal democratic administration, or supposedly liberal democratic administration, that they are now perceived, I think, widely within the journalistic industry as the greatest enemy of press freedom that we have encountered as an industry in at least a generation. And I think it's still not entirely clear to anyone about why that's exactly happened, why this administration in particular has been so anti-press. But I think the facts speak for themselves now. At first, the Obama administration liked to say that the leak investigations that they were pursuing on national security grounds that they had inherited from the Bush administration. And they tried to distance themselves from those at the same time that they were pursuing them. And yet, they continue to pursue new cases. They continue to aggressively investigate every leak that is not directly from the White House. And they continue to talk in bellicose terms about the need for prosecutorial zeal against leakers. I think The General Counsel of the Office of National Intelligence said this week, again, repeated again, that there was a need for aggressive prosecutions of every major leak, and that any leaker in the national security community has to go to jail. I think one of the things that is misunderstood in the press, however, is the idea that this issue can somehow be walled off to a few issues like national security. The problem has been that all leak investigations have been fairly easily, at first, were kind of easy to disassociate themselves. The general industry was able to say, well, that's just a specific story, and then this is a specific story, but now there's a general pattern that's developed that what the administration wants to do, what the government, both the Bush administration and the Obama administration, they want to narrow the field of national security reporting, and they want to make it very difficult for anyone to pursue stories outside of accepted boundaries that the administration itself sets down. That is, to me, what they're trying to do. They're trying to kind of create a path for accepted reporting, and that if you as a reporter go outside those parameters, that you'll be punished, and that the sources that you are trying to deal with will be prosecuted. That is essentially what I think they're trying to do, is create a de facto Official Secrets Act through the use of the Justice Department. The CIA and the White House, I think, are collaborating in a sense to, without congressional approval, be able to make sure that every story that comes out about national security is something that makes the White House look good, makes the CIA look good, and that any story that doesn't make them look good or doesn't help their political cause, the people involved in that story will be punished. I think that is the end result, and if you look back at the kind of stories that Obama and Bush have tried to put out in terms of national security, if you only looked at the stories that had been blessed by the White House, you would find a very different narrative about the war on terror than what the press has actually reported. I think the problem for the future is that it'll be very easy for them to, if they're successful in this kind of prosecutorial zeal, that they will be able to extend this beyond national security reporting into other kinds of reporting in Washington and then beyond. I think also the response of the newspaper industry, the media industry, has been overall, I think, a little bit too hesitant to take on the administration, take on the government directly. There's been the debate, and we're going to get into this at great length, I'm sure, today, about the SHIELD law that has been kind of bouncing around Congress for the last few years and never really gone anywhere. It's a SHIELD law that has a loophole so that essentially national security reporting would not be covered by it. And so basically every leak investigation that's been happening is in national security reporting, so this means that the SHIELD law that's been discussed will have very little effect on real life leak investigations. So I think that one of the things that should be discussed today is how do you strengthen the SHIELD law, and should the journalistic industry support a law that will not really have any effect simply to get something on the books. So I think that to me the real problem we have in the industry today is how forcefully should we stand up to what the administration is doing. I know that reporters and journalists don't like to be political actors. They don't want to take on a role of lobbyists or be a political constituency. And yet we are really confronting a dramatic change in the landscape that we're, in terms of our relationship with the government. And I think it's going to, unless we recognize that, begin to stand up against the administration in some fashion, I think it's only going to get worse. So anyway, I will pass this on to Adam Liptak of the New York Times.
Morning. So as Jim said, I'm Adam Liptak. I cover the Supreme Court for the New York Times. And I do want to say that it's a pleasure to share the stage with him. He's my great colleague in the Washington Bureau and one of the bravest and most important journalists of our day. I hope to cover the request he has at the Supreme Court to review his case with the disinterested Olympian detachment you'd expect from the New York Times. But this is also an area where I practiced as a press lawyer for maybe 14 years before turning to reporting. And if I were still wearing that old hat and I was allowed to have an opinion, I might say that the persecution of Jim Risen by the Obama administration is a scandal. Let me introduce our panelists. As you might suspect from my background, we're going to try to set some legal framework for the discussions that are going to go on today. And we have really, you couldn't ask for better experts on all of this. To my left is Ben Wisner of the Wisner. We discussed this beforehand and I already forgot. Of the ACLU and an advisor to Edward Snowden. After that, Dave Schultz of the Levine, Sullivan, Koch and Schultz firm here in New York City, who has represented journalists in national security matters, as has Laura Handman of Davis Wright Tremaine, who practices in both Washington and New York. And then Jeff Toobin, who's a horrible competitor. He's a triple threat. I write newspaper articles. He manages to write books and New Yorker pieces and comment on CNN. So what I think we want to try to do is set up a little bit of a framework and separate out some of the themes that Jim was talking about in his remarks. And I think there are really, as a legal matter, three categories. There's what can you do to people who have authorized access to classified information, who've taken on some kind of obligation and then decided that it's worthwhile to disclose that information. The second category might be the journalist who doesn't have authorized access to that information, but gets a hold of it and makes a decision about whether to publish or not, what can be done to that person. And then the two things collide in the third category, where let's assume the government is not going to go after the journalist directly and try to criminally prosecute or otherwise punish that journalist, but nonetheless jams up the journalist by asking the journalist to provide evidence about the first category, about the source, the leaker. So why don't I ask Ben to kick off the first category?
The law of leaks in 2 minutes or less.
Oh, right? I've also given the practicing lawyers on the panel the hardest assignment they've ever had in their lives. I've asked them to summarize their areas in 2 minutes apiece, which they're going to find very hard. Jeff, I think, will have no problem with a 2-minute soundbite.
That's long. So I'm talking about the legal regime that faces someone who holds a security clearance, who has a contract with the government not to reveal sensitive, classified, confidential information, but nonetheless does so. And I think the first thing that needs to be said about this is that in the overwhelming majority of the cases, no criminal regime is necessary at all because the loss of security clearance, and the government has almost complete discretion to withdraw security clearance from an individual, generally means the loss of livelihood, the loss of community, the loss of the ability to work in a profession. The combination of those things is enough in almost every case to deter lower level leakers. And as we know, higher level leakers who leak every day don't get prosecuted. You can be a top general and when you or someone on your staff can actually leak a war plan to Bob Woodward, have that published on the front page of the Washington Post in 2009 in order to constrain a first-term president's options, there's not going to be any investigation of that, even though a war plan is sort of the paradigm of the information that probably all of us would say deserves secrecy and shouldn't be leaked. The criminal law, so the Espionage Act of 1917 and some other statutes broadly criminalize gathering, receipt, and dissemination of what's called national defense information. The statute doesn't use the term, or mostly doesn't use the term, classified information. You heard from Jim Risen that the Espionage Act has been used with increasing frequency in recent years to prosecute unauthorized disclosures, including but not only whistleblowing. What's less known is that for most of the 100-year history of this statute, it was only used to prosecute spies. It was not used at all to prosecute leakers. The first person who was ever charged under the Espionage Act with giving information to the press and not to a foreign enemy was Daniel Ellsberg. As we know, that prosecution fell apart before the constitutionality of the legal theory could be tested. This was good for Ellsberg, perhaps not so good for the doctrine. Ellsberg says that he was told that the law clerk to the judge had written a long memo in which he said that the prosecution would have violated the First Amendment. So we might have gotten some interesting doctrine at a time when the Supreme Court might have been more receptive to that kind of critique. Just a few years later, in 1979, the general counsel of the CIA testified to Congress that he couldn't say for certain whether leaks to the press of classified information were even prohibited by criminal law. And he testified that if the Espionage Act made it a crime to disclose defense secrets to the press without subversive intent, then I'm quoting here, "We have had in this country for the last 60 years an absolutely unprecedented crime wave, because surely there have been thousands upon thousands of unauthorized disclosures of classified information, all criminal acts in the Justice Department's view, and yet none has ever been prosecuted." How times have changed. I don't think we would hear the CIA General Counsel testifying to that effect now. And in fact, in a recent court filing, the Department of Justice argued that leaks to the press are actually more pernicious than spies selling secrets to a foreign enemy, because when the newspaper publishes it, all of our enemies get the story, and not just the one who paid for it. Now, the Supreme Court has not addressed yet whether the Espionage Act can, without constitutional limits, be used to prosecute leaks to the press in the public interest or otherwise. But I think it's fairly well established in the lower courts that it can be used that way, and that the term national defense is going to be construed very broadly. And moreover, that the courts are going to look to the executive branch's own classification decisions to help determine the reach of the statute. And it should be said that no court has ever accepted a defense of improper classification in an Espionage Act prosecution. So while there are some ambiguities in these statutes, it's reasonably clear that basically any deliberate leak of classified information to an unauthorized recipient is likely going to fall within the reach of at least one criminal statute. That the government can prosecute most, if not all, employees, ex-employees, contractors for these kinds of leaks, so long as it can prove that the information was not already declassified or in the public domain, and that the defendant knew or should have known that the law prohibited her actions. So to sum up, in other words, a leaker can't escape liability by demonstrating that the public benefits of her conduct far outweighed any claims of government harm or harm to national security, nor can she escape liability by demonstrating that the information that she disclosed should not have been classified in the first place, even if that information revealed criminality on the part of the government. What we have amounts to, or nearly amounts to, and we can disagree about this at the edges, a strict liability legal regime where the executive branch essentially defines the boundaries of what constitutes a crime without really any meaningful judicial review. And just to before I pass it over, to say a word about what the consequences of what this theory are. Think about the information that was classified at the very highest levels of secrecy over the last 10 years that was disclosed without authorization. That the case for war in Iraq was trumped up on bogus evidence, that American soldiers tortured and sexually humiliated prisoners at Abu Ghraib, that the CIA operated a network of secret prisons around the world and used an extraordinary rendition program to kidnap people off the streets and to fly them to those places, that the Bush administration disregarded the constraints of the Foreign Intelligence Surveillance Act and engaged in widespread, warrantless, illegal surveillance. All of these activities were classified. Their disclosure was unlawful, and if we allow the executive branch to decide on its own what the public can see and what the public can't see, we would be deprived of that information.
So Ben mentioned in passing the Pentagon Papers case, which you'll recall was the publication by the New York Times and the Washington Post of a classified history of the Vietnam War. And everyone remembers it as a great win for the press because the Supreme Court said we couldn't be stopped beforehand from publishing it. What people tend to forget is several justices thought that subsequent criminal prosecution of the New York Times was a perfectly good idea. And I want to turn now to Laura to talk about another leg of the stool, not about sources, but about journalists and what kind of liability they might face.
Imagine reporter to source. This is dynamite information. Do you have documents to back it up? Can you get them? Now, that's a conversation that goes on in every newsroom every day. It's what good journalists do. It's what their editors and their lawyers tell them to do. But if the information is related to the national defense, it could be a crime under the Espionage Act, which makes unauthorized receipt, retention, and disclosure a crime. In the 97 years that the act has been on the books, the good news is there has never been a prosecution of the press. And the bad news is there could be. As Adam indicated, the Pentagon Papers was a huge victory, but it did definitely have disturbing dicta to the effect that the paper could be prosecuted. And in 1984, the first time that someone was prosecuted for disclosure to Jane's Defense Weekly of satellite surveillance photos of Soviet aircraft carriers. The magazine was not prosecuted, but the Fourth Circuit rejected Morrison's argument that the act was limited to classic spying and that leaks to the press were exempt. At least two judges recognized, however, that the leaks could involve and implicate First Amendment rights and that the interest of the public had to be balanced against the government interest in national security. But it wasn't until the prosecution in 2005 of two lobbyists for the pro-Israel group AIPAC that before that there had never been a prosecution under the Espionage Act of someone who was not a government employee or not employed by the government, i.e. someone who had signed a non-disclosure agreement and arguably waived their First Amendment rights. Here, the two AIPAC lobbyists were charged under the Espionage Act for willful disclosure to the press and to officials in Israel, and with aiding and abetting disclosure by their DoD source. The source ultimately wore a wire, cooperated with the government, and pled guilty. The freelance reporter who wrote about the investigation was repeatedly visited by the FBI at her home in D.C. until I was retained to represent her. The prosecution begun under Bush was dropped by the Obama administration. Let's at least give them applause for that. Before the reporter was called to testify and face the difficult decisions that now face James Risen. Invoking the Fifth Amendment was an option for the reporter because the AIPAC judge had ruled that the Espionage Act was not limited to persons in a position of trust with the government. And he said that he refused to dismiss the indictment, saying the government did not have to sit back and watch as the threat to national security multiplies, language that in theory could apply to the press as well. The AIPAC judge did say that at least with regard to information, not documents, the government also had to show that they intended to injure the United States or aid a foreign nation. And the government gave up the prosecution, presumably because they did not feel they could meet that burden, and that's a burden that, in all likelihood, would protect the press as well. But in the 8 Espionage Act prosecutions that have been brought since the AIPAC case, all have involved governmental personnel or contractors, all for disclosure to reporters or WikiLeaks, a blogger, and a think tank, but no charges against any of the recipients of the information. In the Drake case, the reporter was never even subpoenaed or contacted by the government. They did not need to. They had all they needed from Drake himself. He ultimately pled guilty to a misdemeanor for misuse of an NSA computer, but got no jail time, no fine, and the judge called the 4-year ordeal unconscionable. In Kim, recently, in support of a search of the reporter's files, the government described the reporter as a co-conspirator because he asked, solicited, and encouraged Kim to disclose sensitive U.S. internal documents and intelligence information. The DOJ has now indicated that it is not going to go after reporters for such, quote, ordinary news gathering. But what is ordinary? Obviously, bribing an official to hand over classified information or stealing the information might not be ordinary. But what if the source, such as Ellsberg, just hands over the classified information? There's a long line of cases, most recently the Bartnicki case in 2001, that the Supreme Court has said the First Amendment does not permit punishment of publication of truthful information that the press has obtained lawfully on about a matter of public interest. In Bartnicki, it was an illegally intercepted wiretap conversation that was delivered anonymously over the transom to the radio station. But more difficult is what if there was not just totally passive receipt of documents or information? What if the reporter asked for the information? When does it become solicitation or aiding and abetting? In Bartnicki, it did not involve harm to the national security, a government interest of the highest order. And it did not involve the deference to the government's assessment of that harm, such as Ben was referring to. The public interest, though, is also of the highest order, where often involving allegations of government wrongdoing and conduct of foreign affairs. The government so far has wisely avoided this head-on confrontation with the First Amendment the prosecution of the press would necessarily and starkly present.
So as Laura says, we've not had the head-on confrontation. We've not had direct prosecution of the press for publishing national security information. But the press gets jammed up in other ways, and I'm going to ask Dave Schultz to talk about that.
Sure, I'll do a quick overview just to set the table, but just listening to these two comments, maybe as an overview, it does seem to me that all the issues that we're talking about this morning are really being driven by two overarching forces that are pushing the government in certain ways. One is the post 9/11 concern about national security. It's like since 9/11, the balance between protecting security and protecting individual rights, including reporters' rights and reporter privilege, has been terribly skewed. And I think all the things that Jim Risen said about the Obama administration are really driven by this focused effort to protect national security and almost an ambivalence to the impact on other rights, a lack of appreciation of the importance of the reporter's privilege. So let me just talk briefly. The issue is, what about the reporter's privilege? Is there a zone of confidentiality within which reporters can operate, an essential zone that's protected by law? And the answer is, right now, that zone is really under threat, and the news is not good in any of the three branches of government. In the courts, the issue of the scope of a reporter's privilege has been never totally well settled. It's pretty well been accepted that there is a reporter's privilege, except in the area of criminal investigations. And ever since a case called McKevitt versus Palish back in 2003, I think.
Just say it with confidence. No one will know.
Okay, 2003. Anyway, it was an opinion by Judge Posner, who just took a blast at all the judges around the country who were reading the one Supreme Court case on this, a case called my mind just went blank. Brandsburg, sorry, from the 70s. Judge Posner said everybody's reading that opinion as creating a right is just wrong, and he has such a reputation and such force that courts around the country started saying, well, maybe we better rethink this. And it's culminated with probably the worst decision for the reporter's opinion in the Jim Risen case, United States versus Sterling, a leaks investigation, where the Fourth Circuit last fall essentially said there is no constitutional privilege, there's no common law privilege, And even if there were a privilege on this sort of a case where you have national security involved, we wouldn't find that it was available. So it just completely wipes it out, and we're doing very poorly in the courts. What about in the executive branch? The truth is that for the last 40 or so years, the single thing that has probably protected journalists the most in dealing with the federal government is our guidelines that were written by the Attorney General about when U.S. attorneys and people in the FBI and others in the Justice Department could subpoena reporters. These are guidelines that were written in the aftermath of Nixon's enemy list and what has been referred to as his war on the press, using agencies and subpoenas to investigate what reporters are doing. The outrage at that time led the Justice Department to impose guidelines that were very strongly worded. They had very strong language about the importance of protecting the news-gathering function from interference by the government. And they essentially imposed upon the Justice Department a qualified privilege. It wasn't absolute, but it was pretty good. So what happens? Fast forward to the Obama administration post 9/11, and you're probably all familiar with the key events last year. We found out in the early spring that the Justice Department, notwithstanding the guidelines, had subpoenaed a massive number of phone records from the Associated Press in a leaks investigation about a story where the CIA or the government had foiled an effort to do a bombing with an underwear bomb on the anniversary of the death of bin Laden. It was a big story. The government was very upset. They investigated for a year, and then without giving notice to the AP, they subpoenaed the AP phone records. There was a big uproar. It shouldn't have happened under the guidelines. The guideline says notice will be given unless it's going to have a harm to the investigation. This was a public investigation. It didn't make any sense. And then very shortly thereafter, it was disclosed that almost a year and a half or 2 years earlier, the Justice Department had also secretly obtained the email communications of Jim Rosen in the Fox case. That's been mentioned here. Again, a huge uproar, and that took it even further because of some peculiarities of the law. To get the email communications, the Justice Department had to proceed by a search warrant. A subpoena wasn't an option. So they had to get a judge to agree with them that this was appropriate. So in the search warrant that they swore out to get these email from Mr. Rosen, they actually accused him of being an aider and abettor or a co-conspiracy, the Espionage Act. This may be the first time in an official court filing that a government official has accused a reporter of violating the Espionage Act. It's really quite shocking. And when it came out and there was the outrage over that, it was very odd because the Justice Department said, well, you shouldn't be so concerned because we never intended to go after him. We just had to say that to get the subpoena, to get the search warrant. So there's a real problem there. The bottom line is that as a result of those two episodes, the President asked the Attorney General to look at the guidelines to see how they could be strengthened. In July, he announced a number of changes, and just 2 weeks ago, released the final rules. And I'll just say two quick things about them. One is they do address those two concerns that were on everybody's minds last year. It changed the rule about when you can go on to get records under a subpoena without notice, and that's good. It made it much more likely notice would be given so reporters could go to court and be heard before their records are taken. And it does say that the Justice Department never again can swear out a search warrant when the reporter is not the target, the actual target of the investigation, just to get the reporter's records. So those things are good. And it does some other things in terms of updating the regulations to reach modern forms of communication, email and other things. But what's quite disturbing about the regulations that just came out is that they have substantial new exceptions to the rules for national security. They have language in them that could be read to suggest that any time the Director of National Intelligence gives an affidavit to the Justice Department saying that a leak investigation is important, that will trump all of the regulations. And they put in a number of other wiggle words that weren't in there before. As Laura mentioned, it now says that these rules only apply to cases of ordinary news gathering, whereas the old ones said they covered all news gathering techniques. And there's a number of other things we could get into the specifics, but it's quite alarming, and it does seem to be driven very much by the intelligence agencies having a control on these processes in ways that are going to have long-term harm to the idea that reporters have the right even to communicate confidentially.
So Jeff, you're the working journalist on the panel, but also a lawyer, former prosecutor. You've given some thought to how all of these legal rules should work on the ground, and they're not only legal rules, of course, they're journalistic norms and ethical norms and responsibilities as citizens. What's the right way to put it all together?
Well, thanks, Adam. It won't take me long to alienate everyone in the room. Journalists are citizens. Journalists do not belong to a privileged caste that exempts us from the rules that apply to everyone else. We've heard a lot of talk. You've heard some talk today about the reporter's privilege. For better or worse, for decades, it has been clear since Brandsburg v. Hayes, there is no reporter's privilege under the First Amendment. You can either engage in tortured readings of Justice Powell's concurring opinion in Brandsburg v. Hayes, and we can have an esoteric discussion about that, but it does not exist. Now, I wish it did. I wish Senator Schumer was successful in his effort to create a federal shield law, but though there are shield laws in, I believe, 49 states, there is not a shield law against federal subpoenas, and we are not exempt from that. And I have to say, I take my inspiration in my view on these issues. I wrote about this some during the Bush administration from a reporter who doesn't get talked about a lot in these grand settings, and that's Walter Pincus of the Washington Post, who was one of the great reporters of our generation. And I don't mean, actually he's somewhat older, and I don't mean to, he can speak for himself, but here is a guy who has done more investigative reporting in national security in a month than I can't even say his name, Greenwald has done in a lifetime. Yet he is the one who gets lectured by Greenwald and company about how he doesn't care about freedom of the press. Now, I do care about freedom of the press, but I think it's important to be realistic about where we stand. And it is also important to be realistic about whether the sky is falling or whether it is not. The number of journalists prosecuted under the Espionage Act in the Obama administration is 0, just as it has been for decades before that. The number of journalists incarcerated by the Obama administration is 0. Yes, Jim Risen has been found in contempt, and I think, or is being, that case is before the courts. I wish that weren't the case. I think it's a bad case. It's a terrible decision. But let's not overestimate how much is happening here. And we are not exempt from criminal laws, from service of process and grand jury investigations. And yes, there should be very narrow exceptions for certain news gathering, but that is not something that has ever been the law in the United States. And to the extent that we claim that it is, the law is against us, the public is against us, and that is just something that I think we need to recognize as we go forward in this discussion. And I just
can I respond to that?
Yes, please.
Just to jump in, I mean, I understand that point of view, and there's an argument that should be made about the correctness of that. But let me just challenge a couple of things. First, in terms of whether we should be concerned about that, there's a whole set of questions we should have about how Walter Pincus operated, and whether people will be able to operate like that in the future as technology makes it virtually impossible for people to leak without detection in ways it couldn't. So that's a question. But in terms of the law and where we are today, I think to say there is no privilege, one gets it wrong. I think what Justice Powell's opinion said is he was unprepared to make a constitutional ruling. He did recognize that there were rights at stake, and his notes, which I recognize are not law, but his notes about that make it clear that what he understood was we shouldn't constitutionalize this, but it should be a privilege that can be recognized on a case-by-case basis, a common law privilege. And I think that's part of the problem, that journalists and lawyers and others who care about these things need to make the public and the courts and legislators and others understand the importance of protecting a zone of confidentiality for reporters. We have a privilege for attorney-client communications. Nobody challenges that. Nobody subpoenas attorneys when they want information in a criminal investigation because that serves a recognized function. Same thing with priest and penitent and spousal. When the Congress subpoenaed an FBI agent, the Justice Department, in 1941, wanting to know the source of certain information that had been leaked from Congress. Then Attorney General Robert Jackson wrote back very politely and said, "I'm really sorry, but if we tell you who our sources are, we won't be able to function. We must have the ability to make a promise of confidentiality that can be enforced." And Congress backed down. That same principle applies to reporters, and what we need to do, is figure out how to articulate the value and the importance to society of protecting that zone of confidentiality. It's like Ben was saying earlier, imagine a world where we didn't know that the CIA had black sites, that we never knew about Abu Ghraib, that we didn't know about waterboarding and torture, that those things wouldn't come out because the government could keep them from coming out. And I think that's the technology issue. And the law didn't recognize any protection either for a reporter who got that information or for the source who leaked it. It's a very problematic future.
Can I just say that I think the technology issue cuts both ways. When Daniel Ellsberg wanted to leak the Pentagon Papers, he had to go to Nomen Copy on Mass Ave in Cambridge and sit there in front of a Xerox machine one page at a time. Chelsea Manning had to hit a couple of buttons to disclose hundreds of thousands of documents. Now, Edward Snowden has not favored us with an explanation of how much he has taken or what he's done with it, but as I understand it, he either took 1 or 4 laptops full of material and gave them to some undisclosed persons for the good of the world. Now, the scale on which leaking can take place with almost no effort, I think changes the balance here somewhat in the other direction as well.
Jeff, why do you think why do you think the Risen case is wrong if you don't think there's a privilege? Why do you think the Fourth Circuit got it wrong?
Well,
or are you
I'm
saying
not
that it's a
a
prosecutorial discretion issue and you just think prosecutors shouldn't do it?
I think prosecutors should not subpoena reporters under most circumstances. That was mostly descriptive on my part, that there is no privilege. I mean, I just think, Justice Powell's notes, with all due respect, are not going to get cited anywhere. I mean, who cares what his notes say?
But let me ask Dave a question. You said, and it's a nice, strong point, that no one would think of subpoenaing a lawyer because of the attorney-client privilege, but there's an exception for crime and fraud.
Sure.
And the situation from the prosecutor's point of view is someone has committed a crime, there's an eyewitness to that crime, that's the journalist. Why does the journalist get a pass?
Okay, and here's the answer to that in part, is that we're just talking about now. You say, well, yes, it's the prosecutor's decision. If we don't recognize a privilege, I'm not arguing for an absolute privilege, like the attorney-client privilege, there could be exceptions. But if the courts don't recognize a privilege, the only person who gets to decide whether to go after a reporter or not is someone sitting in the U.S. Attorney's Office. And we've seen from the recent efforts with AP and with Fox, when you're pursuing an investigation, when you have those blinders on, your zeal to get a result swamps your judgment about everything else. That's why a privilege is important, because then the prosecutor has to go to a judge and someone else has the right to decide whether how that balance works. If you don't recognize a privilege, you are just increasing the power of the executive, and you're taking the judiciary out, and you're changing the whole way that balance works. It's just so critical that we get this right.
And that balance has to include factoring in the public interest, because if you're just looking at how much does the government need the information, that's one part of the equation, but the other part is how much does the public need the information that is being disclosed. And not every leak rises to the level of what Ben was describing, but those that do definitely require that kind of level of protection. And I do think it's a judge that's in the best position to engage in that kind of balancing.
But are we not in a different era technologically where the Pentagon Papers not only had to be copied page by page and delivered in suitcases or whatever, but a grown-up, mature intermediary, the New York Times, looked at it for months, made judgments about what to publish or not. Whereas now we seem to be in a technological world where Daniel Ellsberg wouldn't need the New York Times. Daniel Ellsberg would have the internet. And does that call for a different kind of reasoning, Ben?
I think Daniel Ellsberg could have published the 7,000 pages of the Pentagon Papers in a volume if he wanted to. And I think if you look at the way the Snowden leaks have played out, very slowly for some people who are eager, he worked through news institutions, through The Guardian, through The Washington Post, now The New York Times, NBC News, other outlets. He hasn't published a single document on his own, but has worked through those institutions. WikiLeaks is a different model, although even it worked through The New York Times, Der Spiegel, and The Guardian at first before deciding to go a different way. So I don't think think technology requires us to go outside the normal competition between the press and the government and to use those processes that have developed over decades where the press decides what to publish and what not to publish in the public interest, but consults with the government to make sure that it doesn't have blind spots about what might cause harm.
Yeah. I mean, I think that's an important point. It's just that you're right about technology changing the equation on both sides, and there needs to be thought about how the government can protect its legitimate secrets and how we do that. But I think part of the answer here too is to keep in mind that we need different rules for reporters and for leakers, and part of the problem is technology causes that to merge a bit. With the internet, almost anybody can become a reporter. But when we're talking about the reporter's privilege, we're trying to protect three different things that don't apply just to someone throwing something on the internet. Journalists play a very important checking function on the press, right? They on the government. They are the ones who can critique the government, can help form public opinion, and so that's important that just anybody putting stuff on the internet doesn't play. They disseminate information, which the internet person does, but they also act as a filter. And so we need that in terms of society's functioning. You know, we need organized institutions that help organize information, filter information, and reliably present it in a way that is trustworthy. And those types of institutions need this type of protection. We need to figure out how to carve that out so they're treated differently than the leaker, and they're treated differently than the average citizen. It's how otherwise the system isn't going to work.
I mean, the other impact of the electronic is that, first of all, one reason why you see more leak investigations is because they can, in fact, detect who the leaker is. There have been many, every government wants to pursue who's leaking on them, but before they couldn't ever be successful, in part because of the reporter's privilege, in part because they didn't have a trail. Here, as in the Drake case, there was an electronic trail. You didn't need the reporter, and more, these cases are being made without even having to ever subpoena the reporter. Or the leaker self-identifies, as in the case of Snowden, knowing that the government would be on to him very quickly in any event. So to some extent, the discussion about reporter's privilege is perhaps a thing of the past.
So Jeff, to follow up on Dave's point from a second ago, I suppose we can agree that Manning and Snowden are sources, and that the New York Times and the Guardian and the Washington Post are journalists. Where is like an Assange? Is Assange a journalist? Is WikiLeaks a journalist?
It's a terribly difficult question, and I don't have a fully worked out theory. I just like to point out, though, that when we have these discussions, it is often as if every prosecution is simply a mindless exercise in messing with the press and messing with the messing with well-intentioned leaker/whistleblowers. I mean, you mentioned the Kim case. The Kim case, that's the Fox News case, involves what the government believes was the potential loss of a source in North Korea, which are few and far between, and sources which face certain torture and death if they are disclosed, if they are found out by the North Korean government, as well as 3 generations of their family. Now, you can see why the government is indignant about the potential disclosure of people like this, of sources like this, and that to me is not a frivolous concern on the part of the government. It is not to me, and I promised we wouldn't get into a whole Snowden detour here, that the government is concerned about whatever it is that Mr. Snowden disclosed. Not all leaks are created equal, and not all disclosures should go unpunished by the government.
So that has to be right. And the usual press response is, you can trust us. We think hard about this. We consult with the government. We sometimes withhold details if we're persuaded that they'll do authentic harm to national security. And the government says back, that's nice. Who elected you? And what's the response to that, Dave and Laura? Why should we get to make these decisions?
Well, part of the answer is that someone has got to play a checking role in the government. If you say that it's all up to the government, and I don't disagree with a lot of what you've said, that there are legitimate secrets the government needs to keep, and that it has to have the tools to keep those. But there is a gray area. If the government can keep everything secret, as a society, we're going to wither and die. That's not living in an open society, in a society where citizens can make judgments knowing what the government did. And so the question is, there is always going to be this creative tension, and that's why I would suggest that what the First Amendment says is we protect the press. If they get it wrong, perhaps there are cases where they could be prosecuted. But for the most part, they have the right to disclose information that is true and newsworthy and important for the public to hear, unless we have some very clearly defined boundaries. And one of the problems we have right now is that we're dealing with a law that was written in World War I that just talks about protecting national security information. And the vagueness of it alone is one of the things that creates all of this concern about whether they could go after it. The discretion that it creates itself is problematic.
Can I answer this too? I mean, you could imagine a world in which unauthorized leaks and a free press might legitimately play a smaller role in a democracy, but that would be a world in which, say, congressional intelligence committees played a much larger role, not in secretly rubber stamping the national security programs, but actually in seriously challenging. That would be a world in which federal courts, instead of developing doctrines like judicial deference and state secrets and immunity and standing and all of that, would rigorously consider the constitutionality of these programs. But in a world where we don't have those things, where the federal courts have essentially sat out the national security debates, where Congress has been a miserable overseer, except in moments when it's revitalized by a leaker and a free press, the kind of moment that we're in right now, then we actually need the press. We rely on it in order not just to inform the public about what it has a right and need to know, but also to reinvigorate those traditional oversight bodies like the courts and the Congress.
And just a footnote to that, I would submit that the problems that Ben is talking about the lax oversight by Congress and the failures of the court stem from the fact that those bodies within Congress and the courts that are dealing with this are entirely secret. When you have a system where secrecy is the norm, it doesn't work. You don't have the oversight, you don't have the checking.
And if I can just try to resurrect some part of my reputation as someone who cares about freedom of the press, the answer to your question is quite clear. Who elected you? The Constitution elected us. I mean, there is an explicit constitutional provision, the First Amendment, which protects the freedom of the press. And the idea that the government can tell you what to publish and not is totally anathema, and that is not something that is legally controversial. The prior restraints, the government telling you what to publish or not, is something that really remains, I think, a bedrock principle of constitutional law. Now, where things get complicated and where some of us part company is what are the implications of that publication? Who can be prosecuted, who can be investigated, but the idea that, some president, governor, whoever saying to, you or your bosses, who elected you, that's an easy one.
So you're willing to concede the First Amendment protects the press?
Yes.
Now, we've been mostly talking about the press, but I want to talk about the leakers for a second. And Ben set out very neutrally, although I think he has strong views about some of this, what the sort of statutory congressional law legal regimes are that might get someone like Snowden or Manning, or did get Manning and might get Snowden into trouble. But is there a First Amendment overlay there? Does the First Amendment speech and press clause have something to say about whether, not just as a matter of discretion, but whether there might actually be a defense for someone who violated a legal obligation in aid of what they would say is a more important value?
You want to start?
Go ahead.
Well, I think the answer has to be yes. As I said, the Supreme Court hasn't considered this right now, but there is a doctrine about when public employees have a constitutional right to speak and when they don't. There's no question that someone who is under contract in a privileged relationship with the national security state has reduced constitutional protection, but not none. And my view is that at a minimum, the Constitution puts constraints on the government's ability to criminalize public employee speech where that speech reveals conduct that is illegal, reveals conduct that's criminal, reveals conduct that was improperly withheld from the public in the first place, reveals conduct that has a great public benefit and those benefits outweigh any harms, that at a minimum it should require the government to show that the information was actually properly withheld in the first place, and a classification stamp is not evidence of that, or even if it is evidence of that, it's not conclusive evidence of that, that has to be examined very rigorously. Otherwise, under the current regime, the CIA can, for example, torture prisoners, classify that at the highest level, If somebody were to leak that to the press, they could then demand the prosecution of that person, and that person would have effectively no defense under the law as it stands against a prosecution like that.
And I
Right.
think part of the problem has been that the government has overcharged on all of these cases. Rather than dealing with it as an employee, the remedies that you would take against an employee who breached their contract, they go for the Espionage Act, which really and the Drake case is a perfect example of where they way overstepped what was clearly, at most something that you could remedy through discipline, take away security clearance. I mean, the unruly contest between the government and the press is that the government has the right to control the press access to this information in the first place. All these leaks are where the government failed to do that adequately for one reason or another. But that's the government's first line of defense is, hire the right people, check their security clearance, have the systems in place to not permit leaking. That's their first line of defense, but always going right to the Espionage Act and spying with the massive criminal penalties is not the way to handle leakers in the first place.
But just to follow up on Ben, too, I mean, the First Amendment has to be part of the answer. And again, this is another issue that part of the problem is we have a very little precedent from the courts. But the one time it was kind of touched upon by an appellate court was in the 1980s, the Morrison prosecution under President Reagan. Morrison was a Navy employee who was prosecuted for leaking information to a British magazine. And he raised a sort of a First Amendment defense and a number of others. And when it got up on appeal in the Fourth Circuit, what the court said, the government's position is the Espionage Act is strict liability, and he was arguing there has to be some public interest or other defense. And the court said, without directly articulating what the First Amendment defense was, they said, well, at least on the facts here, we don't think this would be inconsistent with the First Amendment. And they pointed to the fact that it was a knowing violation, that he was paid for the information, that he knew the harm that was going to happen to the United States, and a number of things. And I do think that there is some level of protection, even for a leaker, that would require, as in the APAC case when it was journalists, but that some bad intent and some other knowledge that might not otherwise be evident from the face of the statute.
Adam, if I could just answer your question, which is there some sort of defense for the leaker? The answer is no. Now, Ben would like that answer to be different, that there's some sort of balancing test, and the answer is no under current law. That if you have access to classified information, you are not allowed to disclose it, period, and it's a crime if you do. Now,
There's actually no statute that says that it's a crime to disclose classified information.
You're going to take that argument to the courts?
No, I'm just asking you what statute you think says it's a crime to disclose classified information.
I don't have a citation to Title 18 for you, but anyway.
That's a nomenclature point, I think.
Yes, good luck with that. The point about the only route to disclosure of government misconduct is the press, I think, frankly, is somewhat misstated. Now, you and Mr. Snowden's other advisors and supporters are all like, oh, you can't go to an inspector general because they're a joke. No, they're not. You can't go to Congress because Congress is a joke. No, it's not. I mean, there are other routes for disclosure. And you mentioned Abu Ghraib. It is worth mentioning that one reason it was disclosed is because there was an internal investigation in the Army, which is not made up entirely of torturers and criminals. There were actually lots of people within the Army who were appalled at what went on at Abu Ghraib, and they were investigating it. So, the idea that the press is the only route to ferreting out misconduct is not borne out.
Right, although I'd say situations are different. I mean, it's one thing where something like Abu Ghraib occurs that I think most people in the system were unaware of. When they're exposed to it, they're going to reveal that crimes occurred. And therefore, what's needed is to bring it to an investigator, either internal or in Congress. I view the Snowden situation as quite different, where the regime that he sought to expose was one that the system deemed entirely legal, had approved as legal in secret. He couldn't exactly go to Congress and say, I'm here to report the system of secret surveillance that you authorized. He couldn't go to the head of his agency and say, I'd like to report to you what you're doing every day without telling the American people and that you're lying to Congress about. So there are situations that are, where those channels might not work. That doesn't mean that you think the leaks are legitimate, but to say that Snowden should have gone to Congress when Senator Wyden's hair was on fire, saying, I wish I could tell the American people this, but I can't, it doesn't seem very plausible.
So we're almost out of time. I think I'd like to end with a lightning round. We've mostly been talking about old cases that we love. The press lawyers love to talk about the Pentagon Papers case. Those were the days. Brandsburg was 5-4. We almost got a constitutional reporter's privilege, 5-4. What do you guys think? We'll go down from Jeff and backwards. What do you think the current Supreme Court might do with these questions? Might they recognize a First Amendment privilege for Snowden? Might they rule in favor of Jim Risen?
No. I mean, Adam is highly familiar with the current Supreme Court. I think the recognition of a reporter's privilege is less likely today than it was in, 1973 for Brandsburg. And I think this is a court that defers to prosecutors' judgments in most cases, and I think the best thing for the press is to try to keep a decision away from this court.
Laura?
Well, I think, unfortunately, it all arises in the post-9/11 era, which makes it, I think, much more difficult. And you only have to look at the case that didn't involve the press, Holder versus Humanitarian Law Project, which involved material support for terrorists, to see that there can be, and which the Supreme Court said did not involve First Amendment issues, that you can see that they may not take that friendly an approach to anything that in any way advances or the cause of, or against the cause of national security.
I think in the real world, Jeffrey's judgment is probably a good one, that this is a court you would want to keep that case away from. But your question was, would they recognize the First Amendment right? And I think the answer to that is probably no. Whether you could convince this court to recognize a common law privilege, as Justice Powell's notes urged, I think is an open question. I'm not a wild-eyed optimist, but I think that you could make an argument to this court along the lines of, if you don't recognize this privilege, all you're saying is you're enhancing executive power and you're putting exclusively in the hands of the executive control over a whole field of information. And surely in our system of government, there is a role for judges to play in resolving these important issues. And therefore, you should recognize a case-by-case privilege. Otherwise, you have no role in the future. And you might be able to get someone to coalesce around that.
Yeah, I think that's exactly right. I think the only chance of getting what we would consider to be a good ruling here would be to appeal to the institutional pride of the judiciary and the constitutional role of the judiciary, and show the ways in which it ought to be fed up with the deceits of the security state. During the oral arguments in the Rasool case, the first Guantanamo case, Justice Ginsburg asked, is it your position that this court would have no jurisdiction even if you were torturing prisoners in Guantanamo? And the government said, well, we would never do that. And a month later, 60 Minutes 2 broadcast the photos from Abu Ghraib. The ACLU was in the Supreme Court last year in a challenge to what we consider to be an unconstitutional NSA surveillance program, and the government essentially said to the court, their standing is based on speculation, not on our actions. And the court, in a 5-4 decision, said their claims of standing are abstract, they're attenuated, they have no plausible claim that they or their clients or anyone are subjected to this kind of surveillance. And a few months later, we have the Snowden revelations. So I do hope that the court will see that by deferring to the government excessively when national security is invoked, the court is writing itself out of the Constitution.
Thank you. Please join me in thanking this panel.